Chairman. Thank you, members of the committee. A little stiff, sorry. I have some prepared remarks, but there's been quite a bit of dialogue here today. I thought it might be more useful to respond to some of the questions that we've heard.
Sorry, who do you represent?
I'm sorry, my apologies. Benjamin Aaron, I'm here on behalf of CTIA. We are the trade association for the wireless industry. My apologies. At the very beginning of the session, the sponsor had offered some comments, and he talked about priority lanes, the fear of favoring one's own traffic, and disadvantaging one's competitors. I'm going to get back to priority lanes in a little bit because I think that this is a broader issue. But on favoring one's own traffic, if you do this, this is a violation of antitrust rules, right? You are disadvantaging and or the FTC's rules. So if the premise is we need to protect against favoring our own traffic, this is not any protection more so than exists today. If the issue is disadvantaging your competitors, that's a Sherman Act violation. That's been illegal since whenever the Sherman Act came out, in the 20s, 30s. I mean, that's just an antitrust violation. It would be illegal here in Rhode Island. It's illegal at the federal level. There was an allegation that MetroPCS blocked some streaming. The reality is that MetroPCS had a unique service plan that offered a tier of service that had a certain amount of data or a certain type of streaming that it enabled. So the reality is that there was no blocking that the customer was unaware of. They signed up for a plan that had a tier of service that had that restriction. There was an allegation that the industry discriminated against Google Wallet in favor of their own competing electronic wallet type product. The reality is the phones that were in the market at the time were incapable of operating Google Wallet product. So the failure was actually in the technology. There was an allegation that AT&T blocked FaceTime. The reality of the situation is that Apple had some issues with the way that they were configuring apps on the iPhone, and AT&T removed certain restrictions that might have been in place at the time, but there was no blocking of FaceTime. It was available for download. I'm sorry, FaceTime is the Apple product of competing technologies to FaceTime. Those apps were downloadable from the Apple iStore on AT&T's network at all times. No net neutrality violation. It was alleged, it's actually not an allegation, it's true that Verizon's counsel at oral argument in the United States Court of Appeals said, when asked, would you explore preferred services and the like, Verizon had, I forget which is the case, a product called Go90. And Go90 was very much another product that might be more well known is T-Mobile's Binge On, okay? The concept is that you get free data. I mean, I can't imagine there are too many people in the room who don't like free data. But the concept that Verizon spent time investing in with its Go90 product was to give free data to customers. So when Verizon's attorney is asked, would you look at preferred services and sites, etc., it really should come as no surprise that a company that invested in an innovative offering would answer that yes, they would continue to explore those types of opportunities. The ACLU posited that a divergent set of rules is not a problem. You simply need to obey the rules of the strictest state. The answer to why that's problematic is in the question that was, or the statement posed by the ACLU itself. The answer is, both for Rhode Island, the question is, do you really want another state telling you how your services in Rhode Island are going to be delivered? If our industry has to comply with the strictest rules, then you've lost. Then there's not a national paradigm, so we've lost. So the issue isn't, is the Rhode Island statute on its face okay? We disagree, we don't think it is. But the issue I take with the ACLU statement is, it's not even just Rhode Island. It's that we, the wireless industry, who enables mobility, is no longer able to have a uniform set of rules that applies nationwide. The ACLU said that not all net neutrality violations are against the law. I wish they were still here. I would contend that they absolutely are. As the gentleman from NECTA indicated earlier, I don't see him, but as Tim indicated earlier, the transparency rules that the FCC put in place means that you need to tell your customers how you will operate your network. If you fail to comply with the transparency rules, if you fail to comply with your disclosed practices, you violated the law. It's enforceable. Mr. Chairman, you asked, do we feel that Congress should act? Do we support that? Mr. Chairman, we absolutely support that. We talk to Congress all the time and tell them that we want a uniform national regime for net neutrality, and we do. The ACLU of Rhode Island said, how can the FCC tell states that they cannot regulate the internet if the FCC itself cannot regulate the internet? The answer is simple. It's interstate commerce. It's an interstate service. States are prohibited from, and this is not a controversial concept, states are prohibited from regulating interstate commerce. That's the reason. That's the answer. The gentleman from the Young Democrats said, do this before the protections run out. As Tim pointed out, and maybe the gentleman is too young to remember, the internet as it will exist after these quote-unquote, the FCC's rules run out is the same internet that we have. The same protections exist. That existed before. The same internet that we all grew up with will exist after. So when we say there's a rush to get this done, there really is not. There's an allegation that we will charge higher prices. What about lower prices? What about prioritizing traffic for libraries, for instance? What if we want to make a whole lot of data available for free to libraries? Can we do that? Is that a network priority? Is that paid prioritization? Is it prohibited? The state of Rhode Island was visionary last year in passing a small cell bill, and we really appreciate it, and we look forward to investing. Some of our questions that arise from the deployment of small cells. Self-driving cars, the traffic on 95, we all want it reduced. Do we need to prioritize traffic? Is it more important that a car not crash or that somebody watch bunny videos? And these are some of the important questions that arise from flat prohibitions that don't have, where these answers aren't thought out. They can stymie innovation. And what about competition? We're worried about higher prices. There are 4 national carriers that are at each other's throats at all times to get each other's customers. If you look at their SEC reports, one of their primary data points is churn. Churn is how many customers have I lost to my competitors. In our market, we are highly competitive. There was a question about why are we so against, I think Representative Williams had asked this, why are we so against net neutrality? At the federal level, the issue was never net neutrality. The issue was common carriage regulation. Now, if you were to go to the Rhode Island Public Utilities Commission, Department of Public Service, and ask them, what do they do with a competitive market? Okay, what the PUC would tell you, the DPS would tell you is, we don't regulate it. That's our crown jewel. When you have a competitive market, you allow competition to deliver benefits to consumers. In the wireless industry, we have 4 national carriers, we have many more regional carriers. They're at each other's throats to deliver new and innovative services like Go90, like Binge On, and others. If one of them were to find out that a competitor was throttling, the next thing you would see is television ads. Come over here, we will pay you money to come to my network. You can leave this room today. We have enabled our customers to leave us. Contracts are rare these days, right? Phones are freely interchangeable amongst carriers. You could leave this room today, switch carriers maybe 2 or 3 times by the time you got home, and maybe even get money from the different carriers for doing it. Yet the allegation is that we're going to charge higher prices. 20 years, for 20 years, the cost of voice on our networks has gone straight down. It's a straight line down. Well, it's a diagonal line down, actually. But the point is, 20 years we have fought with each other and competed, and the benefit for consumers has been lower prices. But that's within the consistent regulatory regime that's national. And when you ask why are we against it, it's twofold. We're already competing, so we shouldn't be subject to the regulation you apply to non-competitive markets, right? On one hand. On the other hand, we need the national regime that we've had in our industry since 1993. Zero. Talk about 4 carriers nationally. I want to talk about 0. 0 is the number of net neutrality violations that have ever been found to have been committed by wireless carriers. 0. So the question today, why do we need to protect against? The question is, what are you protecting from? There's been 0. 0 violations of net neutrality practices found to have been committed by CMRS carriers. And I guess one other point from the chair, what are you going to do if net neutrality is repealed? And my answer is, in our industry, we're going to compete ruthlessly with each other to attract each other's customer base the same way we have for years and years and years. And that competition is better protection than you would get under any law. So what will we do when and if the net neutrality provisions are rolled back? We will continue to compete. And those competitive forces have been sufficient to this date, and we would offer they'll be sufficient after this date.
I'm willing to swear that there has been absolutely zero complaints or charges that has occurred.
Not complaints or charges, ma'am. The investigations have shown zero violations of net neutrality.
Violations. I'm willing to swear that there has been zero violations to date.
To my knowledge, I am willing to swear that, yes. Are there investigations that I'm not aware of? Possibly, but all of the major ones that we heard here today, none of those were found to have resulted in a net neutrality violation.
Then you can't say that there are zero. But I will take your word for it. Thank you.
I appreciate that, man. Thank you.
Any questions? I'm sorry, I probably should put this to the last gentleman, but I'm struck by the comments that seem to be this bill provides no protection, or these bills provide no protections that are not already under, provide no protections against behavior that would not be found illegal under other existing protections. Am I hearing that correctly?
Yes.
Okay. So A, I find it hard to believe that you would argue so vociferously against something that provides no additional protections. But B, I think you also said that there is an FTC case to be made if the provider does not live up to assertions it makes to its folks. And I believe this gentleman here read maybe a two-sentence thing that said Cox or whatever the provider is agrees to provide by net neutrality standards. Are you saying that that phrase, net neutrality standards, would somehow be actionable, that people could make a specific case that you violated abiding by net neutrality standards? So it seems so vague to me that you could not possibly launch an action against it.
So I'd start with the premise that if the Federal Trade Commission, under its authority, or the Attorney General of Rhode Island, under the Attorney General's authority, were to find these to be unfair or deceptive trade practices, then it's already a violation, right? Under the FCC's transparency rules, if our transparency disclosures, which we have to make, indicate that we will not block and we will not throttle, then our violation of the disclosed practices is an actionable violation. And to the extent that our companies have announced publicly that they will not do it, I think this is what Tim was alluding to. Those statements may very well be, these public statements that they've all made. I think what Tim was alluding to is those two could be actionable under existing law. I think, Tim, is that paraphrasing? Yes. Okay.
And just I'll point out that that's not the language I heard. What I heard was adherence to net neutrality standards, not that we will not throttle or we will not block. Those seem like very different ways of couching what you will or won't do. But I point.
In Rhode Island, if you have an industry that's regulated by any other government entity, it's exempt from the Pacific Trade Practices statute. So you couldn't be utility like that, under that statute in Rhode Island.
Can I just, no, I'm sorry.
If it's quick.
No, I was going to say that in the Cox statement, it both says our commitment to net neutrality and no throttling, no blocking. So it says both.
Okay, thank you.
Thank you.
Any other questions? If anyone else were to speak on 7422 or 7076? We'll be hearing on that. A motion, Bill.